more minutes, and maybe we'll get started in like 1.5 minutes or so.
Can I ask how many people who are here right now have minor children?
You guys can type in the chat box if you don't want to.
Or I don't know, I don't know if you can raise your hand if you're off camera. I've never tried that.
Mm.
Well, I know that Christine does.
We don't.
Okay. Okay, so we've got 1, 6, and 8. Awesome.
Oh, that thing.
Mm-hmm. Hey, Justin. Justin is our client service director. Justin, do you want to let me know, are we still waiting for a few people, or shall we get started? Actually, it's 12:32, so I'm ready if you give me the thumbs up.
Give me a second. Let me look at our list. I think we might be good to go though.
Yeah, you know what? It's fine. They can just join in when they get here.
Yeah, I would say we're good to go.
Okay. Raven, can you give me the thumbs up if you can hear me and see my screen?
Yes.
Awesome, great. And I just want to make sure I can move through the slides because my clicker is not working. Okay, somebody just entered. I'll let them in. And I have everybody out of the waiting room. I believe so. Okay, hi everybody.
Hi.
Hi Diana, I see that's you who signed in. So if you guys want to mute for now, just in case there's background noise and dogs barking in the background, that's fine. If not, if you're not muted and there's some noise, I may just like mute you on my end. So people are going to be joining us. So we're going to get started here. And my name is Laura Croft. And Raven, do you want to introduce yourself?
Yes, sorry. Raven Sarnoff, nice to meet everybody. Thank you for coming.
Yeah, and today is our free will holiday event. What we're going to be talking about today, we're going to cover a lot of topics. We're going to be covering really everything you need to know about estate planning basics. And of course, we're going to go over, and you guys might have questions about, is a will enough? When would I, need something more? What does that look like? What is a will? What is a trust? That's really common questions we get all the time, and we're going to address all that in addition to other documents that you need to make sure that your family stays out of court and conflict, that your assets go to who you want, that your children are protected. So we're going to cover all of that today. And of course, we're also going to let you know how to give the free gift, get the free gift at the end that we're offering. And we want you to stick around at the end so we can let you know how, in fact, to get that free gift and what that is and the steps that you need to take if you're ready to move forward. Let's see if I can click through this. There we go. Oh, that's too fast. At Timeless Estate Planning, we take a very modern approach to estate planning. And what that means is a typical estate planning usually is very documents driven. If anybody's done an estate plan, typical experiences, you go in, you sit down with a lawyer, you get a big stack of documents, you give them your check, and most people walk out and they don't know what all that legal, jargon means. They put it under their bed, never look at it again, don't remember their lawyer's name. And then as their life changes, they don't go and ask the questions. They don't update their plan. And then all of a sudden, they feel like they've done everything, but yet they pass away and their family finds themselves in probate and court and conflict. That is because they have no ongoing relationship with the lawyer. So it's very important to us that we have that type of relationship with our clients. And I always show this picture that I have here, and there's a funny story behind it. I always say, doesn't this look like such a beautiful family photo? You have the kids, running around, their matching outfits, beautiful scenery. And I tell people what they wouldn't know, what they don't know is we had to hike up it was a 20-minute hike up this hill, and I had my dress hiked up, and I was carrying my son the whole way. And that son that I'm holding there, he was 14 in this picture. Now he is a small 14-year-old, but he is autistic, and autistic kids, it's like a thing, often do not like to put their feet in grass, or especially this tall hay. So I was sweating and my clothes were dirty and my kids were probably fighting in this picture. And I tell that story because often families look very perfect on the outside, or at least look lovely on the outside. We see them on social media and we have these thoughts about them. But the truth is that every family has their own unique struggles, has their own fears, has their own hopes and dreams. And it's really important that we understand what that looks like. So part of when I say that we have a very relationship-based practice, it's very important for us to know, what do you really, really want for your family, and make sure that your plan addresses all of the things you want for your family. So you leave behind the legacy that you want and it's important to you, rather than what could often be something that looks very different, and often that looks like court and conflict. And that's what we want to avoid. So this more modern approach, this relationship approach to estate planning that we place such a big emphasis on, how do we attain that? How do we create that type of relationship with our clients? And the first thing is that we do everything on a flat rate fee. And we do that more for transparency. What am I getting? How much does it cost me? We want to be really clear about that. That's what I would want to know. But really important, that sets us off from other firms, is that included in the flat rate fee is our ongoing support. It means that you call our office, and it might be a question about your estate plan. It might be a question because you got in an accident, you're looking for a personal injury lawyer. It may be something different, but we are here to support you and provide that legal advice on an ongoing basis. And we do not bill for that. That is included in your plan. So typically when you call a law firm, you may be getting a bill in the mail. If it's 20 minutes, it could be $200. What happens then? And Raven and I both know this because we have a background in litigation. People don't call. They don't call, they Google, they don't find the answers, and they do nothing. And now what happens is we have a real expensive mess on our hands down the road. So for us, we want our clients to call. We want to get out in front of any problems and be really proactive. So when you call our office, we don't charge you for that ongoing advice and support. What that doesn't include, and I always like to say this up front, what that doesn't include is ongoing legal work. It should be clear, but we couldn't offer an unlimited lifetime of legal work. So our legal work product is not included in the flat rate fee. Second thing is that we make sure to track your assets and family wealth inventory. So it's very clear to your family, something happens to you, what do you have and how do they find it? I can't tell you how many times people come to us and they ask us to review their plans, and we ask them, okay, is your house titled in the name of your trust? I don't know. What about your life insurance? Have you named beneficiaries? I don't know. Are these all of your accounts? I don't know. Very, very likely that even we don't know all of our own assets, but think about how hard it is for a family member to step in and try to find the assets. If they don't know where to look, it eventually goes to the State Department of California's unclaimed property. So it's something we place a really big emphasis on. And then the last thing there is we check in every 3 years. Automatically, we do not wait for you to come to us with a problem. Automatically, every 3 years, you get a postcard and an email that says, it's been 3 years. Let's check in. Has anything changed? If so, let's make sure that your plan reflects it. So I'm going to hand it over to Raven. Get you guys thinking.
Hi, everybody. My first question that I want to ask everyone is, do you have an estate plan? Does anybody who's here, and I don't know if you guys can raise your hand or put it in the chat, does anybody already have a plan of some sort?
No.
Okay, we've got a no. All right, well, that's good enough. If you don't currently have an estate plan, my question is, why do you not have an estate plan? Is it because you think that you're too busy? Is it because you think you're too young? Do you think it's going to be too expensive?
Procrastination.
Or, sorry, what was that?
Procrastination.
Procrastination. Yes, we will definitely talk about procrastination. That is the #1 impediment to getting an estate plan done. We try to do everything we can to head that off. But yes, that is the number one reason why people don't have a plan in place. And unfortunately, that means it's often too late. And you hear, you know, things about famous people like Prince who die and they don't have any planning in place, and we all get to see their will on TV. You know, probably know more about that than most of us, Christine, since you live in LA and, you know, you see all that kind of stuff. Anyhow, or do you not have an estate plan because of the number one biggest fear, which is that planning for it will hasten its occurrence? And I can tell you with confidence, we have people come in here all the time who come and do their estate planning, and there's absolutely no correlation between getting your estate planning done and then passing away. So you can just throw that one out the window. That is not a real thing. I want to tell you that you're in the right place if you have someone or something that you care about and that you want to protect. You are in the right place. Maybe you filled in a fill in the blank. Maybe you went on LegalZoom or Susie Orman or one of these things, and either you finished it and you're not sure if it's really going to work. Spoiler alert, probably not. Or maybe you got halfway through and you realized that you were being asked legal questions and you didn't know what to do, and now you want to actually reach out to a lawyer. You're in the right place if that's something that you did. You're in the right place if you're nervous about how much this is going to cost. We're going to talk about that. Because the reality is that estate planning is not about you. You're not going to benefit from the plan that we make. It's really about the people that you love the most, and you know, making them feel taken care of when the time comes. Today, what we're going to do is we're going to learn about, we're basically going to look at, you know, what happens if you were to pass away today with no plan in place. What happens? And then we're going to look at the alternative, which is what does it look like with estate planning in place? So you can see those two different perspectives. And of course, we're going to also talk about how you can get your free will and if that's really enough for you and your family. We're going to talk about all the details about how to start, how long it's going to take, and how much it's going to cost. So this is my family. We also take photos in grass. Apparently, that's what all the photographers are doing. And you know, Laura and I are both moms. We have, 6 children between us at this point. And you know, what being a mom really brings to me in this experience is that, as I said, you know, estate planning is not going to be for you. You're not going to benefit from this. This is really going to be something that you do for your loved ones, where you're either going to leave them with a mess or you're going to make them feel really taken care of even when you're gone. And, you know, I like to share a story from my life. My grandmother passed away a few years ago, and unbeknownst to me and my mom, she had actually made all of the arrangements for her funeral. She wanted her ashes scattered on the San Francisco Bay. She had the whole thing arranged through the Neptune Society. She paid for it. It was all set. And it was actually a really, really beautiful thing and a beautiful day. And my mom and I just felt so relieved and so taken care of, because we never would have known that's what she wanted to do. And it just really felt like she had just done one more thing for us, even after she was gone. And that's really what we want to put in place for our families, is we want to put a plan in place so that they're not in court, they're not in conflict, but instead they feel like, wow, you really took care of it, even after you passed away. All right, so I want to talk a little bit about, you know, what do we do to protect children? We always say we want to keep you out of court and conflict, and we also want to keep your children out of the care of strangers. So what can we do to protect your children? I want to talk first about who would care for your children if you were to pass away in the short term. So I'm not talking about who would end up ultimately being the guardians for your kids, but what would happen if you were to go out to dinner with your spouse or co-parent and you were to get in a car accident and you never got home, and your children are at home with a babysitter or a nanny or a neighbor or maybe even your parents? What's going to happen? Well, what's going to happen in the short term is that CPS is going to be called. And unless there's somebody who has documented legal authority giving them the right to take custody of those children, even just in the short term, the police are going to call CPS. Now, we get the question a lot, well, what if it's my parents? And that's a tough one, right? So if they're there with your parents, well, maybe they should just be able to take over. And maybe some cops would say that, and maybe they would let them stay with the parents instead of going to CPS, but maybe not. And I actually just spoke to a San Francisco police officer just recently, and I asked her, what would you do in the situation the parents don't show up there with the grandparents? And she actually said, full stop, 100% calling CPS. If there's nothing that's in writing, that's documented, that's legal, that somebody can take those kids, I don't know what that relationship with the parents. I don't know what the family would want. Those kids are going to CPS. So I don't know about you, but I would not want my kids to be in somebody else's custody, the custody of a stranger, for even one night. And I'm sure if you have kids that you wouldn't either. So we're going to talk about what can we do to stop that situation. All right, so we've talked a little about what would happen in the short term if you were to pass away. Now, what would happen in the long term? If you don't have legal documentation designating legal guardians, and I don't mean that you've chosen somebody as their godparents and you had a church ceremony or anything like that. I mean, you have actually executed legal documentation designating who guardians are going to be if you were to pass away. There is a plan, but you're not going to like it. So the plan is that a judge is going to decide your future. A complete stranger who doesn't know you, doesn't know your family, is going to decide who your kids go with. And I like to tell a story about some friends of mine. I'm going to call them Tom and Mary. That's not their names, but they really are real people. And if anything were to ever happen to them, they are in the fortunate position that both sets of grandparents would want to take those children. So in that case, both grandparents would petition the court to become the guardians. And here's the information that the judge would have about Tom and Mary, because remember, you're only going to have what's going to be on paper. So Tom's parents are very, very wealthy. They own multiple homes. They have done international travel. They were able to send both of their children to medical school, and they emerged debt-free. Very, very privileged life. Mary's parents, on the other hand, are, just much more regular people, more modest. Mary went to public schools. They weren't able to travel internationally. She didn't go to fancy private schools like Tom's parents did. Just a more regular family. So now you're the judge, and this is the information you have. Who are you going to give the kids to? Does anybody want to make a guess? Okay, well, we know who's going to get the kids, right? It's going to be the rich ones, because that's all the information that the judge has. And he sees that they can provide for those children in a way that Mary's parents can't. And so while it seems like an obvious choice, it's actually completely the wrong choice, because Tom and Mary, as much as they love Tom's parents, his parents are completely at odds with their values, would not raise the kids in the way that they would and the way that they wanted to. And it would not be what their choice would be. And the even more tragic part of this is what might likely happen is then you've got Tom's parents and Mary's parents battling it out in court with each other. Now you've got a family that's in conflict in court, and you've got these kids who have already lost their parents and don't need any more conflict or loss in their life. And so, that's why it's important to have actual legal documentation in place for figuring out where the kids are going to go. Okay, so this is all terrible. What are we going to do? So because we have a real focus on kids and families at our firm, we have something that's called the Kids Protection Plan. And it's a whole packet of things to keep your kids out of the care of strangers. So at its most basic level, it's a folder with instructions to the babysitter. If I don't come home tonight, here are the people that you call. And we have what we call short-term guardians. We actually prepare legal paperwork that a list of people who you know and choose have documented legal authority to take your kids in the short term. Could be the same people as the guardians, the long-term guardians, could not be. So for example, let's say you want your parents who live on the East Coast to take your children if you were to pass away. Great. Well, they're not going to be able to get to the kids fast enough. So you might put down a neighbor who, your kids play together. You might put down some school friends, somebody who's close that are going to be good enough, better than strangers in that short-term time. We also then have a little card that you can put in your wallet. And that card basically just says, stop. If anything happens to me, I have minor children. please call the following people. They have legal authority to take the kids. And then we have in the folder a set of legal documents which show that those people are allowed to take the kids. And then we also prepare documentation so that those people you choose receive that documentation as well. So between the two sides, at least one of you should have the paperwork available in that emergency situation. We also do medical powers of attorneys for minor children so they can get medical care in a circumstance like that. We also do something that not everybody needs this, but if you need to do what's called the confidential exclusion of guardian. So let's say you've got that crazy sister-in-law that you would never want to take your kids. We can prepare paperwork which basically says, under no circumstances do I want this person to take the children if anything were to happen to me, and here's why. And what that does is if the person is thinking of taking the children, either they'll get that paperwork before going to court, or if they do go to court and petition for guardianship, that can be submitted to the court so that the court will not give the children to that person. Now, that person's never, ever going to see that paperwork unless that situation arises. So nobody's feelings have to be hurt in the event that that never happens. But especially if it's somebody like a sister-in-law or a parent who you think a judge without further information would assume you would want to take them, you really got to have that documentation in place so that your wishes are, put down in writing in a legal manner that the judge can look at. Make it as easy as possible for the judge, basically. We also have something we call a family wealth legacy interview, which I'm going to talk about later. But those are the major pieces of the kids protection plan. Okay. I think, I've talked a lot about what's going to happen with kids. Now, what about your assets? What's going to happen to that? I'm going to have Laura will talk about those.
Yeah, and thank you, Raven. And hopefully you guys can tell that so much of our focus is not just on documents only, which is very typical in estate planning and traditional planning. So much is focused on how do we make this work on a practical level. Great that you have the documents, but how do we make them work at the time when we really need them? So a lot of our focus is on that. And Raven shared all about the kids protection plan. We also have you share that, and we let the individuals know that who've been named. So this isn't a surprise to them. This is something that's, oh, okay, I know what's happening here. And this is, again, we really want to cover all the bases if we're doing this plan to make sure it works. What I'm going to talk about now is, okay, what happens to your assets? How will your family receive your assets? Is a will enough? This is the part that's really going to focus on what is a will, what is a trust, is a will enough? And in the state of California, if you have real property, so if you own a home or you own vacant land, you have real property, or you have over $165,000 without an effective beneficiary. An effective beneficiary is someone who is over 18 years of age and alive. Like, you actually have to name the beneficiaries, and they have to be alive, and they can't be minors. So if you have either of those, your assets automatically go through probate. There's one caveat: unless you have a trust in place. I'll focus on that part of it. But for now, if you guys are sitting here without a plan, state of California's plan says that if you have real property, assets over $165,000, it is going to probate. Probate is a court process. What probate means is a loved one, maybe it's a spouse, maybe it's a parent, maybe it's a child or a friend, has to go and open up a court case. So they have to go and open up a probate case. At that time, your assets are going to be subject to estate tax. If you are over the estate tax limit, there's no way to do any planning, subject to creditors, subject to lawsuits at that time if it goes through probate. A will is not enough. So we often get this question, well, I think I need a will. And we understand why people say that. It's because every movie you see, it's glamorized the will reading process. Everybody sits down, they read the will. That is not realistic, right? That is not how it happens. It's not the will that we really need in most cases. Okay, so usually a will is not enough. Usually a will is the document that a judge is reading in court. That means you are in court. That means you are in probate. What we want to do, what our goal is, to always keep you out of court, always keep your family out of conflict, make sure that your assets are given to the people you want and choose at the ages that are appropriate for them, and is never, and really in the privacy of your home, or if you get a lawyer to help you. But the whole point is to keep it out of the court process. A will guarantees the court process. So if here will guarantees probate, and then it goes to your heirs. And that's kind of a funny picture, but that's Anna Nicole Smith. And she was famous because she went through probate so many times and then ended up with nothing. And it was very much an ongoing probate case. But you don't get to decide who your assets go to and how it goes to them if it goes through probate. What exactly is probate? And why do we care? It's good questions. So probate's a lawsuit. And it's a lawsuit you file against yourself with your own money for the benefit of creditors when you're no longer here. It's paid for out of your estate. Sounds crazy and convoluted, but still, why do people want to avoid probate? The first reason why people come to us, they think, or they've been told, or maybe it's their financial planner or a real estate agent or life insurance. Somebody said to them, you know what, you should get a trust in place. You want to avoid probate. Why? Number one reason, and I think this is the first reason people come to us, I don't think it's the most important reason, but it's definitely a good one, is that it's super expensive. So you guys can, if you have a piece of paper there, we call like a back of the napkin, calculations. But probate costs roughly 5 to 10% of your gross estate. Okay. What we're looking at here is a family. We've got Ned and Kat. Maybe they have a home that's worth a gross value of 1.4 million, some stocks and bonds at 150,000, life insurance, maybe some businesses or retirement plans. You can see how this number goes up really quickly. If you got a couple $1 million in life insurance, it keeps going up, right? So this family has $3 million, doesn't feel like liquidity, doesn't feel like cash. It's not, but this is what would go through probate. 5% of $3 million is $150,000. It is super expensive. We want that money going to your family and not to the courts. What does it all cover is a good question. Another thing, we hear 5%. I often hear it can go up to 10% or higher. So 150,000 doubled. We've got 300,000 for probate fees. We want to avoid that. It is completely avoidable if you work with attorneys who are going to make sure that your assets don't go through probate. Why is it so expensive? That's crazy. Well, that's court fees, filing fees, corporate fiduciaries, appraisals, bonds, legal fees. Legal fees are a huge chunk of this. It's usually based on the percentage of the estate. So that number gets really high. And again, it's what we really want to avoid. And those of you are thinking right now, we always ask the question, who wants to avoid probate? I do. I definitely do. I think most people do. So the next reason that we want to avoid probate, one, it's expensive. Two, it's public. It's completely public in nature. I'm showing you Anna Nicole Smith's will here, and that's because I can, because it's public. For maybe the average person that isn't worried because of the publicity for their family, what you're doing is you're putting the world on notice that your heirs or your beneficiaries or your children are about to get a big chunk of money. Because what happens is after it goes through probate, if you have minors, often the court will appoint somebody to manage the assets, and their guardians have to go in every year with a budget to get those distributions. But when your children or when your beneficiaries turn 18, they are getting an outright distribution of their remainder at that time. And it's outright, which means that at that time, it's subject to lawsuits, creditors, and if they're going to get married and commingle it and divorce a few years later, they're going to lose half of it. Scary part in here, I was saying, this is public. You're putting the world on notice that two 18-year-olds or 18-year-olds are getting a big lump sum of money. Maybe it's $1.5 million, much easier to scam an 18-year-old than it is, an investor or a business individual that just got, $1.5 million. The other big thing in here that we're always thinking about is, oh my gosh, what does it mean for your 18-year-old to get $1.5 million? That could be the scariest part of probate if you have minor children or if your beneficiary is young. I always think of, I have this friend in law school, actually she was in college, undergrad, and she got a distribution, I think it was a lot less than that, it was around 400,000. She did not finish college. She ended up dropping out of college, and she was, living the good life for quite a while, but she did not work through her 20s. She did not continue her education. She rounds out her 30s and she had blown through her inheritance. So now she had no money, no education, no work experience, and her parents weren't there to guide her. And to her, she was the victim. I mean, she was like, very victim mentality. To other people, they would have thought, you got $500,000 and you blew it. So we want to make sure that our assets go, that the inheritance goes to our children, to our beneficiaries, people we choose at the ages where it's appropriate and it's going to enhance their life, and with protection. So it's not lost to lawsuits and creditors and divorces. Also really important to note here, if any of you have children who have special needs or have a beneficiary that's receiving government benefits, if it goes through probate and it goes outright to them, they are automatically losing their benefits at that time. So that could be very detrimental. And that's something that we talk a lot about, because we want to make sure whatever goes out to your beneficiary is really going to put them in the best place possible and not what could, essentially really hurt them in any way. So if your assets go through probate, that's the first thing. If you don't have a trust in place, if you only have a will and you have assets that are over 165,000 or real property, that would be the probate scenario. Also, I'd like to touch on estate taxes. Everybody has an estate tax exemption, and there's lots of planning we can do during your lifetime to minimize your estate tax liability. Currently, everybody's estate tax exemption, it's pretty high. We're still under Trump's tax plan. We all get a coupon. I like to call it a coupon. We get a coupon and we're not taxed on anything unless we have over that coupon amount. So right now it's close to $12 million for an individual, $24 million if you're married. You get to combine your coupons. So, we like to mention it. It is very high, but it is going to sunset at the end of 2025 and go back to what it was during the Obama administration. It's very political in nature, so it changes a lot. And also with that is, we don't know when someone's going to die, and we certainly don't know what the estate tax exemption is going to be at that time. Very important to have that kind of a working relationship with your attorney, because that's something that we're watching all the time. If there's planning we need to do to minimize your estate tax liability, we certainly want to do it. So your assets are going to your family, to your beneficiaries, and not to the US Treasury. One other thing is, I spoke about in the beginning, why it's so important to have your assets inventoried and make it really clear on where your beneficiaries or the person who's going to step in and administer your trust, how and where they can find your assets. This is something where when we have children coming to us, they say, my parents passed away and I need to know what their assets are. And we say, well, did they have them inventory? Did they work with a lawyer that, may have a list of these assets and where to find them and how to find them? And they say, well, no, we don't know. Can't we just type it in somewhere? No, the answer is no. At that point, it's kind of like our advice is you got to sit around at the mailbox for a year. What happens is if you haven't inventoried your assets and your family doesn't know to go find where to find them, and they don't claim them, eventually they go to the State Department of Unclaimed Property. And there's $58 billion in the United States in unclaimed property. And it's not because somebody, forgot to go and claim some small bill here and there. It's really from when people die and their families just do not know what assets they have or where to find them. So whether it's $20,000 or $200 or $2 million, we want those assets to go to your family and not to the state of California. So what can we do? Now, if you don't have any property and you don't have any children and you're not concerned on who would step in and make decisions if you're incapacitated, Raven's going to talk about that in a second. And if you're not concerned about how your assets go or who they go to and at what age they go to, then a will may be enough. Other than that, wills do very little in the state of California. Other than that, if you have real property, if you have minor children, if you have assets over $165,000, the only way to avoid probate is to have a trust in place. And it's not just a trust, but that trust actually has to be connected to every asset you have. So when it says a fully funded living trust, that means your assets are connected to your trust. That is part of the process that we walk you through. So only foolproof way to avoid court is to have a living trust in place. And the living trust stands in the shoes of a judge. Instead of a judge determining what happens to your assets and following very specific probate code, the trust stands in that place and says exactly how you want your assets to go and to whom they're going to go to. And then it avoids this whole court process and all the, the terrible things that I went through of what probate entails. And then the second part is, yes, your assets have to be connected to the trust. This is something that we help you walk through and make sure that it happens. Your home has to be retitled in the name of your trust. Your life insurance, we would name beneficiaries, name the trust as the beneficiary of the life insurance. Again, though, that's something that we make sure that happens. And up at the top there, it actually says a fully funded living trust with disability provisions. This is something we check for whenever we review a trust. So if you have a trust and you want us to review it, we're looking for these disability provisions. Think of them more than disability as safety net provisions. This is, one of these items, what we're looking for, and we often don't see them in trust. We want to make sure if a distribution is going out to a beneficiary and they're homeless, or they have a mental illness, or they're receiving government benefits because they have special needs, or they have a gambling problem or addiction, we want to make sure that we're able to take specific measures to make sure that this is being held in a way where they're not going to have full access to the assets and it's not going to be detrimental to them. I always tell the story. I have a very close friend and family member, and her mother passed away. Actually, her mother's mother passed away as her grandmother, and her mother was about to get a distribution of money, and her mother was homeless. She had mental illness. She was homeless at the time. And so they came to me and said, what can we do? And what happened was the lawyer ended up not doing anything. We wanted them to go to court to adjust it. They ended up giving this woman the distribution, and she, died within a year. So these are really, really important. We really want to make sure that nothing's going to somebody who it's really going to hurt them. We want it to be able to help your beneficiaries so they can, live the best life possible. And we can make sure that your trust is a real treasure chest. And we say that because one of the things that we specialize in is asset protection. One of the things, if you want to keep wealth continuing in your family, giving an outright distribution to someone often is not the best course of action. Sometimes it is, but often it's not. We want to make sure that it goes to our beneficiaries in a way that's protected from lawsuits. If we get an outright distribution and they're sued, they can lose it all. We want to make sure it's protected from creditors. And we want to make sure, probably the most common thing that happens is people get an inheritance, they commingle it with their spouse, they get divorced some point later, and they're losing half their inheritance. So there's definitely ways that we step in and we protect the assets. And we can also make sure that your wishes of what you really, really want, what really reflects your legacy, is reflected in your plan. This is, a really important aspect. And this is why we say this relationship-based planning that's so important to us is something that can be reflected in your trust. It should be very specific. What do you want to happen to your assets? And then multi-generation planning, often we work with, maybe it's a parent and they realize this would be really beneficial for their children and grandchildren, or it's, somebody who is, we're working with the child and they realize, wow, if something happens to my parents, I'm going to be the one in probate. So often we work with multi-generations, and then there's ways within your actual plan that we can ensure the assets continue from generation to generation. Raven, I'm going to hand it over to you. Raven's going to talk about, sometimes call a living will, or it's your directives for when you're alive, but possibly incapacitated.
All right, thank you. All right, so I don't know how many of you guys remember, but this here is a picture of Terry Schiavo. And for those of you who don't remember, Terry Schiavo was a young woman who had a heart attack, and she went into a coma, and the doctors did everything they could for about 2 years, and they finally declared her in a permanent vegetative state. Her husband at that point was willing to let go. Her parents were not. And what ensued was a 15-year court battle, a media circus. At some point, the president of the United States got involved, complete loss of privacy, hundreds of thousands of dollars in fees, and a family torn apart. As just like to set some context, when Terry went into the coma, she was 26 years old. And by the time this all was done, she was 41. So a lifetime of fighting because they didn't have essentially a simple document, which is a comprehensive healthcare directive. That's something that, we want to make sure when we're doing planning, it's not necessarily just for your death, but we include that documentation that's going to be important if you're ever incapacitated. Another thing that we always want to include in a complete comprehensive plan is a power of attorney. So if you were to become incapacitated at some point, you would want there to be somebody who could step in and basically take over your financial life. So, pay your bills, handle all of the, financial decisions, rent, whatever you would be paying for and signing your name to. Other than if you have a joint account with your spouse, even your spouse can't take over everything in your life and take over all of the things that you can do on your own. And if somebody's incapacitated, it's too late at that point. So you've got to have that in place before you need it. And the only alternative, if you don't have the power of attorney in place, is you've got to go in and get a conservatorship. And what is that? That's a court process. You've got to go in, you got to have somebody who's appointed to be a conservator. That conservator has to be able to post a bond, which is very expensive. And the judge has to decide that that person, hopefully the person who you would want to be your conservator, would be chosen by the judge to do that. And if not, the judge decides that person is not financially responsible enough, or the person can't post the bond, then you're going to have to hire a professional conservator. And again, it's money, it's conflict, it's court. And again, if you just take care of it now, it's relatively simple. It's a huge, huge mess if you wait until it's too late and you're incapacitated. Next slide. All right. So we've talked about, what do we do? How do we pass out our money? How do we protect our children? What do we do if we're incapacitated? We also like to do one more thing, and that is help families to pass on their values. Your kids are not going to keep their trust by your beds, but we offer something that's included with all of our plans. You don't have to do it, but you can if you want to. And essentially it's a recorded interview. What would you want to say to your children when you're gone? What would you want to pass on to them? What would you want to make sure that they knew was important to you? And, whatever it is that you'd want to say, and it's in your voice. So they say that one of the first things to go is your memory of someone's voice. And so that's something that, children really cherish if they have. Now, could you do this yourself? Yes. Will you? No. So, we just put that on the calendar, make sure it gets done, record it for you, and then give it with your full package so that you can, give your kids something really special. All right, so now we're kind of coming to the end, and I want you to start thinking about, what do you need? What do you need to protect your family? Do you need a will? Do you need a trust? Do you have minor children such that you need the kids protection plan? Do you need to avoid probate? Do you need to avoid state taxes? Do you need some sort of asset protection planning, i.e., giving somebody money in a way that's protected from lawsuits, creditors, and divorce, as opposed to just outright? All right, well, we've given you a lot of information, and the good news is you don't have to do this alone. This is what we're here for. This is not something that you should be trusting to Google. This is not something that you should be entrusting to a form online. We are here for this. We are here to help you. We've gone to law school. We want to be there, and we want to guide you through this entire process. All right, so Laura talked a little bit about this at the beginning. We want to give you an experience that is different than the traditional law firm experience. What is the traditional experience? Hourly fees. We don't do that. We do everything on a flat rate. Why? Because we want you to call us. We want, if, in the future you have your plan, you buy a new home, we want you to call us. Hey, how do I retitle that? You get new assets, a new baby. What do I do now? We want to be able to tell you what to do and not have you be afraid to call us. Knee-jerk response to reactions is the traditional experience. We don't want to have that. We want to have an ongoing relationship. We want to have ongoing communications with you so that we're not responding to things when they've become problems, but we're getting ahead of things so there aren't problems. Traditional experience, you're a transaction. This is not about making a pile of documents and handing them to you and never seeing you again. Again, we want to check in every 3 years. We want to say, hey, how are you doing? How does that estate tax exemption look? Have you had any new family members join the family? Divorce, marriage, new home, anything like that. We want to check in and keep that relationship going. So your assets don't get disconnected from your trust. I think, can I get the next slide? Oh, so I'm gonna turn it over to Laura, who's gonna talk about how do we do this? What's our process? How long does it take, et cetera? How much does it cost? All the questions that you probably really want to know.
Yeah, everything we went over, already is so important, but we do want to make sure that you have the knowledge and the information and the tools to move forward. And we say, once somebody's ready to move forward, we want to make it as easy as possible for them to do so. Number one reason, and I think somebody had said this in the beginning, number one reason that people don't have a plan in place is not because they don't think they need one, is because it's so easy to put off. It's so easy to procrastinate. Why? Why is it? Well, we understand why. It's really hard to sit down and talk about some of the biggest things in our lives, and the things lots of us are programmed to have so many issues around. We're talking about money, we're talking about family, we're talking about our children. Then we've got to meet with the lawyer, and then we've got to pay money, and then we've got to talk about our mortality. We get it. These are really, really hard things, but the travesty, the tragedy comes when people do nothing. And now we're dealing with court, and now we're dealing with conflict. And it's not just that, it's actually the part that you can't place a dollar amount on is really the experience that's left with the family members. It's very traumatic. It's very frustrating to have to deal with judges and lawyers when you want to be mourning someone's loss, celebrating their life. So like we said, we want to make this as easy as possible for you. In fact, everybody who's here today, we're giving you this gift because we want to see people get a plan in place. And, if that possibly, we are going to give you with some time slots open before the end of the year. If that's something that you're ready for, again, we want to give you the tools to do that. So we start all planning with what we call as a family wealth planning session. In a family wealth planning session, you come in, you sit down with us. This is a very strategic session. This is not a meet and greet. This is not we're taking down your name and information. We've already done that. This is where we're sitting down and we're going through, what does it look like for you under the state of California if something were to happen to you, and do we want to put a plan in place? Do you want to put your own plan in place? So we go through that, we check in, we talk about pricing. If it's a good fit, we start designing your plan. We want to make sure that everything's fresh in your mind. We schedule the signing out in about 4 weeks. During that time, we're preparing your documents, we're gathering information, we're retitling your property, and then you're coming in, you're signing everything. We're sending you home with directions on what to do with all of your assets. And then we're having a final meeting 4 weeks later, making sure that everything's buttoned up. So from the start until when it's legal, it's 4 weeks. The whole process, we say, takes about 8 weeks. How much does this cost? So I'm going to go to the next slide to go over this. And is it worth it? Is it worth it to do this type of planning? It's a really good question. I think everybody should be asking them, is this something I need to do? Is this worth it? If you have a home that's $500,000, probate's going to cost, minimum $25,000. It is almost always worth it. And certainly if it wasn't worth it, you wouldn't be doing it. And we would be telling you, you don't need to do this. That would be the answer. That's how far we would go. So, yes, it's worth it. It's worth it. We think that, it's always worth it, but realistically, anybody over 18 needs some planning in place. Anybody over 18 has, things that they want to protect, whether it's their healthcare decisions or it's, their home or their child. So how much is this going to cost is a really good question. So our plans start at $1,500. They may go up to $8,000. They may go up to $10,000. Sometimes it's really expensive. Sometimes people have multiple trusts that they need. That is not typical. Typically, a plan is not $1,500 and it's not $10,000. Most plans are somewhere right in the middle. But the promise I can give to you is that we're going to get really clear on it before you decide to move forward. And that's that promise to you, that we're going to be as transparent as possible so you're able to make these decisions with, your eyes wide open. And that's why it says they're all flat fees agreed to in advance, and there's no surprises there. So we want to get into the part we said, we promised you guys a free will or estate planning services worth $1,000. Now, if you do not have real property, if you do not have assets over $165,000, if you do not have minor children, if you're not concerned with who's making your medical decisions, if you don't need a power of attorney, or you're okay with people having to go to court and put a conservatorship in place, then a will would be enough. But I imagine for most of you, because it's for most of our clients and most of the people we talk to, that a will is really not enough. And it's very much a false sense of security and is landing people's families and children in a worse off position than they would be. So if you have minor children, if you have real property, if you have assets over $165,000, if you want to make sure that you are taking control of who gets to make healthcare decisions for you, who gets to make any final disposition instructions, decisions for you, if you want to make sure who's able to communicate with doctors, if you want to make sure you have a comprehensive guardianship plan in place, all of those things, then I would say a will is not enough. And that's why we're giving you guys the option. And of course, it's up to you. Our other, gift is $1,000 worth of estate planning services. That's going to include a complimentary family wealth planning session. Our only requirement for that is you got to do the homework in advance and you got to bring your spouse with you. We need both spouses there. At a family wealth planning session, it's worth $750. And then in addition to that, we're giving you $250 off any estate planning services. Actually, Raven and I, we talked before and we actually are going to up that because we're doing a December promotion for $500 off. So this ticket now is worth $1,000. It's $750 and we're upping that to $1,250. So the catch is you've got to get started in the month of December. We opened up a few days next week, and then I'm actually going to be here that last week in December. I'm going to be working. So a lot of people have this time free. That's why I've opened up my calendar, and Raven's going to be around too. So we've opened up our calendars because this is a time when a lot of people aren't working and we want to make sure that we're available to serve you if you're ready to move forward. So what I want you to do is I'm actually gonna unmute Justin. Or Justin, are you able to pop on the screen? I want to introduce Justin. Justin is our client service director. And Justin's working from home today because his Christmas starts today. But Justin's our client service director, and Justin is the one who helps walk you through a lot of the process. Justin, if you scroll down on your chat, everybody here, and if you click on Justin Owens, you can let him know what you want to claim. If it's the free will or it's the $1,250 off estate planning services. So let him know so he knows how to reach out to you. And Justin, do you want them to give like a phone number? What's the best way for you to communicate?
I would say, respond to the emails that were sent out that, shared the Zoom link that you registered with first to reserve your spot. The info@Timeless Estate Planning email will work. Also the 650-787-4142 number that I texted everyone, or most people who signed up the Zoom link as well. That number is our office cell phone, so calling or texting at that number works as well.
Yeah, that's a great way to get in touch with Justin if you have any questions. But also definitely if you guys are ready to claim one of these gifts, we want you to do it now so we're clear on who wants to claim those. So you can click on Justin's in the chat and let him know. And then Justin, you can follow up with everybody, but make sure you are able to take note of that.
I would say texting might be the easiest just because I don't know what happens to the Zoom messages when they go away. So I would say text me at the 650-787-4142 number. It's our office cell phone. It's below all of our contact information. I say texting me at that number with your name, number, and then which one you'd like to kind of redeem.
Okay, so everybody got that. I'm going to write in the chat the number. This is Justin's number. There, that's the office line. That's the quickest way to get in touch with us. Does anybody? So what I want to do is I want to open it up to a few questions right now, and let people ask any questions. And I might actually, so since we have very limited slots for the rest of December and we want you to be able to claim that $500, while you guys are asking questions, I might type some of those time slots in there. And when you text Justin, let him know that you want to claim that open slot if that's something that you want to do. And again, we want to make sure that people have the opportunity to put this important planning in place if they're ready to move forward. So if anybody wants to ask any questions, I'll let Raven, you can go ahead and answer them while I type some of these times in. I kind of have to check now.
Does anyone have any questions? Okay.
And if not, and we understand, because sometimes it's like, what I always say, the questions that people are asking on here is the questions that everybody has. Like everybody has that question. I guarantee you. If we weren't clear on something or you need clarification, certainly you can also just type it into the chat box.
I have a question.
Yes.
So, before we were to make an appointment for next week, would it require entire payment upfront, or do you do payment plans?
That's a good question. So before you made the appointment, what would happen is you call Justin, find out you guys would schedule the appointment, and he would send you a link for your online homework. The homework is the intake. So we're getting all that information really, so Raven and I can come to that meeting fully prepared, and you're prepared also. So we're not taking down that information at the meeting. Then we have that meeting and we walk through everything. So we're not taking payment up front until we agree this is a good fit, till you're clear on how much it's going to cost you. And then at that meeting, when we do the design, that's when we take payment. Sometimes people want to pay up front. That's great. We're happy to do that. And then often we're happy to do payment plans. Often we do half up front and then the remainder at the signing. That would be the typical payment plan, but we're certainly willing to work with you.
Great, thank you.
Yeah, we have a philosophy that if people are ready to move forward, we do want to work with them to make sure that they can put the planning in place. Yeah, I'm going to say, rather than me write some of these time slots in here, and it's, we have some next week, and then that last week, we've opened up the week for this, specifically for this event. You can just talk to Justin and he can help you find a time that works for everybody. Yeah, any other questions or clarifications for what the process looks like moving forward?
Hi, Laura.
Hi.
Hi. Hi, Raven.
Hi, Diana. I recognize your voice. I don't see you, but I recognize your voice.
Oh, okay. I'm in my office. Is the audio okay?
Yeah.
Yeah. Okay. Thank you so much. This was really useful. Quick question. I'll try to make it brief. I'm already in a situation where I'm dealing with a messy estate, living trust. My father recently passed away. And so I'm wondering if we have a trustee who is being challenging and not following the kind of, what I understand to be the probate codes and some of the role, the role of the trustee and what's really being a good trustee. Do you provide possible mediation in a situation like this? And, if we're trying to avoid getting to courts, and it might become a court case anyway, because it probably be properties that are going to be under probate, but a messy court situation. Do you get involved with the other attorney, the opposing attorney, if we get to that point, and or provide mediation situations like this?
Good question. First, I'm so sorry to hear about your father passing. I know how important he was to you and your family. Wonderful.
And thank you for that, Laura. I can't imagine how many people you speak to do this work, hospital lawyers who provide no compassion. So thank you so much.
It's really true. It's really true. As lawyers, we tend to be like, okay, here's your issue. We're going to launch back into this. And we meet as a team and we talk about a reminder to ourselves that people are coming to us because they've lost someone extremely important to them. Right. And I know how important your father was to you and your children's lives. So I'm really sorry to hear that. Really. And to answer your question, so we don't do litigation, right? I mean, that is really litigious. This is conflict. We don't do litigation. We do work closely with people who do. We do know, I have people right now in the back of my head that I'm thinking about who I would refer you to. We have done some mediation. We certainly could, but that's something that's not really our focus either, is the mediation. Sometimes I'll mediate certain issues with families. And Raven, do you have a background in mediation?
My husband's mediator.
Her husband's a mediator as well. It's specific for employment law. He's a very great mediator. So it just depends. Sometimes I do, it's more like off the, I would say informal mediation, but certainly that is something that we do though, is build relationships with other lawyers and professionals that practice and approach law, but life like we do. We have those connections. We're referring to people who we care about the bigger picture and care about the person, right? You know, Raven and I do this. We both have a background in litigation. We do this because we love to help families. You know, we would not be doing this if we weren't. We maybe work in a big law firm or something. So yeah, I mean, Diane, I can definitely get you in the name of a few probate attorneys that I think would be good for you. I have 2 in mind right now.
Okay, great. I'll be in touch. Thanks, Laura.
Absolutely.
No, thank you.
Yeah, thanks for joining. Good to see you.
Yeah, this was really informative. Thanks so much for offering it.
Yeah. So there's a question here from Joel. Are those one-time fees or is there another cost at the 3-year check-in? Great question, Joel. So it is a one-time fee. That includes our 3-year check-in. Now at the check-in, I want to say, so there's no confusion. At the check-in, if there's legal work that needs to be done, like let's say something drastic has changed, like you got a divorce and you got remarried, or you want to change all your trustees, then we're doing actual legal work product. And there is a fee to that. Those fees, you know, if you're working with the same lawyer, you know, if you go to a new lawyer, it's always going to be more expensive. If you're working with us, it's usually, we say, well, worth it to make the changes, right? At that point, it's not, I don't want to make it seem like it's nothing, but it's not going to be cost prohibitive. It's not going to be like putting a plan in place. They're usually just minor changes we need to make at that point, and there's a fee, but the review is automatic. There is no fee for that. And then every time you call the office, you may call, you know, Raven or I, and it might be a whole discussion about taxes, and we don't have a clock. We don't bill by the hour. Where lawyers are charged, you know, $600 to $1,000 an hour, that 20-minute call can be super expensive. There is a huge value to that, especially if you like to run things by lawyers. We have Justin, who helps a lot of our funding, and we have Cora. And Cora is like very much, she takes the lead on a lot of our deeds and property issues. So, you know, you may be working with any one of us, but there is not a fee to that ongoing support and advice. If it becomes where it's like you want to sit and meet with Raven about something that's not really related to your plan, and it's more of like an issue where this is going to be like a couple hours, we'll talk about that. We'll say, again, that's really not part of this. Why don't you come in? We'll talk about what that looks like at that time.
Yeah. So anything additional is kind of a la carte. Like if we add a second home or something later down the road, you have to go back in and change something. It's kind of a la carte, just depending on what changes are being made.
Yeah, so that's actually an interesting question. And now something like buying a new home, changing property, we don't actually change the trust because it still goes to your beneficiaries. There's no cost to that because you're calling me and saying, or calling Raven and saying, hey, Laura, we bought this new property. What should we do? And if you could call us, which we want you to do, we're saying, hey, Joel, make sure you take title. You tell the title company, I want to take title in the name of my trust. Here's my certification of trust. That doesn't cost you anything. We're just telling you how to handle your asset at that point. If
there's an additional property or an inheritance or something, that would be a change.
Sure. Yeah. If there was something where you needed like a new trust, then yes. Then it might be a matter where we're changing. Only if we're changing your documents though. If you're just changing how the asset's titled, there's nothing you need to pay us. So yeah, I mean, you could say it's kind of like, well, we will talk about it and see what it is and then let you know.
Yeah, but if you buy a new home, that's not going to cost anything because we're just going to tell you how to title that new home.
Yeah, got it.
And that's why we want you to call us, right? Because that's a super simple question, but with huge consequences if you don't do it.
All right, thank you.
Yeah.
Yeah. Okay, there's a question here and it says, does the golden ticket basically provide a free initial consultation, then the $500 off if we decide to proceed? Yes, that's exactly it. It's the golden ticket is towards that complimentary family well planning session and then an additional $500 off any planning that you do. The one thing to that was, it's something that it's for the month. You got to get started in the month of December. And then Raven, are you able to see the chat also? If you want to, you can take any of these questions.
Some of them, I didn't see that last one. Let's see. Is this the right number?
I hope so. Let me go back.
650-787-4142.
Maybe put a 1 first, Melanie. That is the right number. Try putting a 1 first. That's very strange. Can you try again and let us know? Okay, cool. Somebody also asked Raven, is it acceptable to update an existing trust rather than develop a whole new one? Do you want to take that?
Yeah, I think that was sent directly to you because I don't see that one.
Oh, okay. Do you want to take that?
Sure. So So the issue is if you have already worked with another lawyer, it might, and you just want to make a small amendment to your trust, it might make more sense to go back to that lawyer and just do an amendment. If you're going to bring us a trust, we're not going to probably be able to do an amendment to another lawyer's trust because, we don't know what kind of legal errors, what kind of malpractice we might be taking on if we were to basically take on that trust and then add our information on it and then have our names on it. So if it's an amendment, we're most likely going to have to redo the trust and do a whole new trust. If you are already our client and we already did your trust and you need an amendment, then that's going to be a much smaller fee. I hope that answered the question.
Yeah, and important to note that when you redo your trust, whether it's with us, anybody else, we call it a restatement, or you might hear that. But the good thing is you don't have to actually ever change the name and date of your trust. You always keep the same name and date. So you don't have to go and retitle all your assets. Did you say that, Raven?
I didn't say that. No.
Oh, I'm sorry. I was just
That's
all of a
great
sudden
point.
thinking I was being repetitive. I apologize.
Oh, no. That's perfect.
Okay,
Yeah, exactly.
It's a little less work the second time around. It's just, you always keep that same name and signing date. It's just called a restated document at that point. All right, I don't have any other questions here. Certainly you guys can ask any questions. You have the phone number. I'm gonna probably have Justin follow up just with an email to everybody, just so you are able to get in communication with him. I know that some people, it seemed like they tried to call and it didn't go through, but that is our correct number. I wonder if the 1 needs to be there. I don't know. That's bizarre. Did I put in the right number? Second guessing myself. Yeah, 7874142. Okay. So yeah, I'll have Justin follow up with you so you can make sure that you can take advantage of our gifts today if you want to. And then you'll also have his contact so you can reach out to him at any time and we can help you find a date that works for you if you're ready to move forward. So thanks everybody for coming today. We love to see y'all.
Thank you.
All right, have a good happy holidays.
Thank you. Very informative. Thanks.